Okay, so just to go over this week's reading assignment, as we move beyond the drafting of the Constitution. Now we got to get the Constitution ratified, and we've got to tack on the Bill of Rights. So that's what we're going to be focused on this week. I did list the chapter introduction. I think that should kind of go without saying. Read those chapter introductions. They really help you set up the context. This first primary source document in the textbook this week is a George Mason argument against the Constitution as proposed. George Mason was one of the major figures at the Constitutional Convention. He was a very wealthy plantation owner, made his wealth in tobacco primarily, but also traded in other agricultural products. He was a major slaveholder in Virginia, sort of really represented the Virginia. He represented the Virginia elites in a lot of ways. And he would turn out to be one of the 3 delegates to the convention that would not sign the Constitution. He opposed it for a number of reasons, not just the fact that it lacked the Bill of Rights, although that's what this excerpt you're reading deals mostly with, but it does also get around to some of the other issues he had with the proposed Constitution, and especially he saw the president as being given too much power through the executive branch in the Constitution. So he thought that was he wanted power to stay basically closer to home and specifically to the state. So he would have definitely been a states' writer in terms of, he would want Virginia to have primacy over the federal government in most areas. And again, this is why he didn't like the Constitution, especially with its strong executive. He also mentions the president pardon power is maybe too broad, and that's relevant today. Whenever presidents pardon someone, as recently Trump pardoned Joe Arpaio down in Arizona, it can be controversial, especially one like that, which is very controversial. But just the power the president has to pardon is something that may be in the news. It has been in the news, and it's not just Trump. It's, Obama had some very controversial pardons. George W. Bush did. Bill Clinton did. I mean, thinking back, these are just, and I can specifically remember those. George Mason is sort of addressing that in this article or in his objections as well. Okay, the next is Madison's advocacy for a Bill of Rights. This is after ratification during the very first Congress. In fact, one of the very first proposals floated was this by Madison to create amendments to the Constitution and address these issues. So this is the document that's going to inspire the crafting of the first 10 amendments, which then become the Bill of Rights. He does deal with the argument that what if we are seen as enumerating all the rights? So, for instance, if it's not included in the Bill of Rights, is it a right? And that's the topic for the discussion I'm setting up for this week, and it's also something that Madison deals with the Ninth Amendment. And that's essentially what our discussion is this week, so I won't dwell too much on it, but start considering that as an issue. And start considering whether or not you think the Ninth Amendment is the way to deal with that issue. Finally, there's an article in the textbook on the effects of the Anti-Federalists. So, as you know now, the Constitution is being debated. It's been written. Now it's up to the states to decide whether or not to ratify, and essentially when 9 states ratify, the Constitution goes into effect. So we're having this big national argument, should we ratify, shouldn't we ratify? And it's the Federalists who favor the Constitution versus the Anti-Federalists who are against it. And this article makes a pretty good case. I'll let you read it and determine for yourself what kind of case it makes, but a historical argument that the Anti-Federalists during this period, the people who opposed the Constitution really articulated a theory of freedom that still resonates to today. It's a very American version of freedom. And a lot of it has to do with states' rights and limits on the national government and the limits of the federal system. So read that and see what kind of case he makes. And then there's a few interactives and some online. There's a lot of online material here. So let me show you what that is. This is the first link. It's a little bit more background, a little bit more detail, and then a lot of interactive links that can really be helpful. So this one's actually in the textbook. I didn't assign it. This is the one that I did assign that's in the textbook. But then there's also lots of other resources that aren't in the textbook dealing with this, and most notably the Brutus versus Federalist. So Brutus was an anti-federalist who published lots of essays in the New York papers arguing against the Constitution. And meanwhile, the Federalist papers, most notably by Madison, but also by Alex Hamilton and John Jay, Federalist number 10, written by Publius, which was common. They're both, Brutus and Publius, are references back to the Roman Republic, and the American Republic as built was very highly inspired by the Roman Republic. So this is why they're using these as pen names. Anyways, our Federalist 10 is extremely important to the articulation of why a federal system can actually work, especially in such a big country. It's got a couple of the other Federalist papers, lots of the amendments that are coming up during ratifying conventions. These are then going to go on to inspire the Bill of Rights. Here are the Bill of Rights as proposed. So some good documents here at this site for you to browse around in and hopefully get some more idea of what was going on with the ratification effort. And then these last two, I focus on a couple of amendments in the Bill of Rights that are have been adjudicated, at least in some sense. And so I want you to first start with the Second Amendment. Here's what the Second Amendment says: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So that says one thing, and today, as it's been adjudicated by courts, and including the Supreme Court, that basically guarantees every individual in America the right to own a handgun and various other weapons. Notice it doesn't say anything about guns. It says arms, for one thing, and arms can be considered any sort of weaponry. So in some sense, I think it's fair to say that this amendment has been expanded in scope, but it's also been reduced because there's no court that really recognizes your right to own a fully automatic machine gun, at least without the proper certifications and authorizations. Same goes for rocket launchers and F-16s and thermonuclear devices. Those are all arms. So in other words, arms has now been limited down to mean basically firearms, rifles, semi-automatic rifles, and handguns. So it's been limited, but it's also been expanded in some sense because it applies to all individuals, and as written, it seems to be more of a group right. So in a sense, it seems like the right of a militia rather than the right of an individual. So anyways, and then these timelines are really nice. So you'll see the first adjudication was in 1837, and then it goes 90 years before there's another major change in the way we understand the Second Amendment. So throughout all this time, most Americans, at least on the frontier, owned a gun. It was just necessary to survival, and it was understood that should war come, all those citizens with their guns would be rounded into well-regulated militia to fight the enemy, fight the common enemy. So, and then you'll see lots of adjudication, regulation of automatic weapons in 1934, federal regulations on gun sales, mandatory registration of shotguns, sawed-off shotguns become illegal. So, and you can see a lot of this is happening with the growth of organized crime in America. The mob and mob violence is really inspiring those early ones. And then here we are now with the Brady Law and the so-called assault rifle ban of the 90s. And then the most significant recent adjudication was the Heller case. It's in here. I can't seem to find it. Oh, it talks about Heller over here. Maybe that's where I'm remembering it. The U.S. Supreme Court stepped in, ruling in 2008 that an individual has a right to own a gun for personal use. However, District of Columbia versus Heller addressed only federal laws. In 2010, the court handed gun rights supporters a major victory when it said in McDonald v. Chicago that the Second Amendment applies equally to the federal government and the states. So in other words, that's the current state of the laws. All individuals can own a gun. Neither the federal government nor state governments can infringe on that right. Okay, and the final is the same type of interactive. This one has to do with the Fourth Amendment. You're protected against unreasonable search and seizure. I think you'll see as you go through this that the courts have tended to side with the police when it comes to determining whether or not a search has been unreasonable, or a seizure for that matter. And you'll see there's lots of recent court cases dealing with this issue. As you can expect, as technology develops, police develop new ways to search you and different ways to look for evidence that you've committed a crime. And for instance, like the good faith exception says that if a police officer acts in good faith, they're typically okay. In other words, if they think they have a warrant, that's valid, and they act in good faith on that warrant, even if it should prove to be invalid, that doesn't necessarily exempt the evidence from being relevant in court. Okay, so that's the end of the assignment for this week. I hope these are helpful in helping you understand these specific amendments, and we'll talk about the Bill of Rights in broader detail in one of the lectures. Okay, see you.